Hello everyone, I'm Ishwari Pendse, and today we'll be discussing about civil trials in India. And before we start with the session, I hope that I'm audible to everyone. And just for the technical team to check a few things, we are waiting for 10 minutes, and then we'll start with our session today. I hope I'm audible to you guys. In about 10 minutes, we'll start with our session then. Uh, yeah, it's all set. I start with that. Okay. Okay. Sure. Yeah. 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 Thank you. No, five. I got the instructions from the organizers in about 5 to 6 minutes. We'll commence with our session today. Hello, can you hear me? Hello. Yeah, sure. I'm sorry. I'll repeat what all I have said earlier. So basically, today we'll be dealing with civil trials, and when we are dealing with civil trials, we have to address CPC, Code of Civil Procedure in general. Now, when I was talking with Vivek at that time, I actually asked him that why a fresh graduate right now, because there are so many experienced people who will be able to give better insights into civil trial, into CPC. But so at that time, I realized that maybe the intention of what the discussion is going to be today isn't just about bombarding you with a lot of information. What we are trying, or what I'll personally try today, is tell you certain experiences, tell you things that I have encountered in this year of practice. I'm practicing yes, I'm practicing in Pune court right now. I'm actually working with one senior who has been practicing majorly in civil cases, in civil trial courts in Pune. And there's a very small experience that I'll like to share with you. So it was, just after getting the sanad, it was my first day, wherein I had to appear before the judge. And of course, the senior instructed me over the phone because he was unwell and he couldn't come to the court. He instructed that go and give this push, give this application. Uh, so at that time, he instructed me things, and I went to the court. The only thing was that I couldn't understand what stage the case was actually at in the court. At that time, we had Section 9A CPC being repealed, which deals with preliminary issue. So even though the argument was related to preliminary issue and the evidence had to be adduced for preliminary issue, I didn't know that how the courts are dealing after Section 9A of the CPC has been removed. So I was confused, and I did some submissions before the judge. At that time, the judge understood that I did not know anything about the stage that is going on, and it would be better that if someone explains the same to me. So the judge took time and he explained me that at what stage we are actually arguing right now. And he explained it to me very nicely and properly. He also explained to the clerk that what all the clerk needs to give to me. And you can see that it was not just the judge, it was not just the clerk, but also the lawyer who was representing the opposite side. He also came out of the courtroom and helped me deal with the issue. So I just wanted to tell that in trial courts generally, there are people who are ready to help you. Okay, you need not be scared. The court clerks, judges, everyone wishes that you work a lot as young lawyers, and at the same time, if you're putting in effort, they'll surely help you with the proceedings. Um, as a student, I would suggest that when you're interested in civil trial, the best option is to go to the court. Okay, learn a lot in the courtroom. The difference between you guys, like the students today, and me is just a simple thing that you guys are learning for like 5 6 hours in the classrooms, whereas I have to learn for 5 6 hours in the courtroom. Okay, at that time, sometimes you mess up things and everything, but eventually there are seniors who will help you. Seniors always find time to help you with everything. And as students, I would suggest that you do internships in variety of fields. Okay, so for example, I did an internship everywhere. Like I did it in an NGO. I was working on prison reforms. Then I was working in trial courts. I also did one internship with the Advocate General. And eventually, after graduating, you need to decide that it's not just learning. The place where you actually learn things, it's not just the learning that is important for you right now. Along with the learning experience, you need growth as an advocate. and many a times trial court actually helps you. Trial court helps you to grow as a lawyer. So today, because I have experienced the good parts in the trial court, I would like to discuss with you what are the important things that you need to understand if you wish to enter into trial court practice, especially just after graduation. Okay. So today, actually, I know that there are two sessions. So today's session, I'm going to be discussing a pre-litigation stage, wherein there are going to be various compliances. Okay. Then the second stage will be actually drafting of the plaint and institution of the suit. The third stage will be, add interim ex parte reliefs if at all you are claiming any. Then the fourth one will be summons. Okay, that's bringing the defendant to the court. The fifth one will be written statement, and of course the say for your exhibit 5 or interim relief in any pre. And the next part is the interim relief. Actually, the stage of interim relief. So now today let's first begin with the pre-litigation stage. Now, as you know that there are certain compliances that you need to cater to before you institute a suit. If you do not, if you fail to have those compliances, there are chances that your suit will be barred or your suit will fail. For example, if you take Section 80 of the CPC, now, Section 80 of CPC states that if you want to institute a suit against central government or the state government, okay, at that time you need to give, it is mandatory for you to give a 2 month notice to those concerned officers. The process how you have to give a notice and all has been discussed in Section 80. I won't go into all those details. So the notice should basically comprise of what is the cause of action, the description of the plaintiff, the place of residence of the plaintiff, what remedies you are asking. All these parts need to be stipulated into the notice. If you have given the notice and you wait for 2 month period, then only you will be able to file a suit. Now, the intention behind this provision is that it's a government. You're actually going for a suit against a government. There are going to be public stakes that are involved. So it is better that if the government is able to arrive at a mediation or a settlement even before the even before you approach the court, that is that is the intention behind this provision. Likewise, under Municipal Corporation Act, there's Maharashtra Municipal Corporation Act. I know that here people are going to be from many places other than Maharashtra also. But as I am practicing in Pune, unfortunately, my examples will be closely related to that because I have experienced those. So, under the Maharashtra Municipal Corporation Act, there is something called as a mandatory notice that needs to be given to the municipal corporation. Now, we had filed a case wherein we were challenging the legality of certain orders and actions of the corporation. There are case laws pertaining to it that when I'm challenging the legality of any order, okay, at that time I need not give a notice to the corporation. But unlike Section 80 subclause 2, which gives you, waiver of the notice. So it basically states that if there is urgency in the matter, then there is no need for notice. Okay, you need to give an application or for waiver. The court will give an order to that effect, and then you will be given the interim relief accordingly. But there is no waiver provision in the Municipal Corporations Act. So when there is no waiver provision, we need not give any application for waiver. And our case is actually related to legality of the actions. We are challenging the wires of the order itself. And there have been cases which state that you need not give any notice when you're challenging the orders. And so we proceeded with the case. We filed the case, and eventually the filing officers, I mean the clerks over there, they took they and we state that we need not give the notice, we are not ready to comply with it, at the filing stage itself, the matter goes before the judge. Okay. And this, now mind you, this whole practice is going before the filing. That is, we are not here for first order, so there is no case number given to us. So we had to go before the judge, and the judge stated that, there are various case laws of the Bombay High Court, the Supreme Court, that wherein we are challenging the legality, we need not give notice. But because the judge wanted to take abundant caution, he gave us a better option. He told us that give a notice only of 1 week. Okay, instead of 1 month, we had to give a notice only of 1 week and come after 1 week. So over there, after 1 week, when we showed that yes, we have complied with your orders, at that time the case was actually taken up. Okay, we were given the case number and proper courtroom was allotted to us. At the same time, and instead of going directly to the court, let's try to settle it. Because come on, everyone knows that there is a burden on the court system. There are too many cases. There is, there have been times wherein we have, like my generation, people are arguing on a case that was filed in 1990. So that's the reason that why this idea of giving notice, not only the statutory notice but also notices which will help us to arrive at a settlement, is required. Now once you have done with these compliances, okay, the next part will be drafting of plea. And actually I'll just like to tell that I'm seeing that many people are writing questions. I'll surely try to answer most of your questions at the end of the session. Okay, so now we come for the drafting of the plaint. To be frank with you guys, drafting of the plaint is really difficult. Okay, it's seriously difficult. And as a fresh graduate, person who has just got the sana, then you are working with some senior. It's like very few times the senior actually gives you to work on a plaint. He may give you to work on written statements, but plaint is something which is very difficult to draft because you have to interact with the clients. Now I have observed my senior doing this, that whenever there are new clients who wish to institute a new case before the court, he actually tries to contemplate that what their situation is. Okay, then what reliefs they want, what documents do they have. So while drafting of the plaint, you have to think even the end result. Okay, it is not, you have to strategize at the time of drafting of the plaint itself, like what evidence I can give, what evidence do they have, how strong is my case. At the same time, we need to have relevant case laws related to that case also. This actually helps us in having a better case in the future, to strategize our case, because eventually the most important stage is the evidence. What evidence you can give so that the court will decide in your favor. All of that needs to be looked at the drafting of plain stage itself. Now, when you're drafting a plaint, usually you see that you will get many clients who are speaking about various things. Okay, and the actual substance that will go into the plaint might be very little. At that time, you have to determine that what exactly is a civil right that has been involved over here of your client. Okay, now you have section 9 of CPC, which states that all suits of civil nature will be tried by the civil court unless and until barred by law. Now, there are two concepts in section 9. One is right of civil nature, and the second one is jurisdiction. Okay, so when we say the word civil, it simply pertains to private rights and remedies of a citizen. Civil suits are suits between subject and subjects dealing with the civil right. So this section is generally stated as a section which recognizes common law remedies also. For example, tort. Okay, if I have a case related to defamation, I have the right to file the case because section 9 gives me the right to file, to institute a suit. Okay. There's a very interesting case. Today, my intention is not to bombard you with various case laws. Okay, but this case is very interesting. That is the reason why I'll be discussing that. This is Sinha Ramanuja versus Ramanuja. It is a 1961 Supreme case. Under Section 9, you have explanations related to religious office. Now, what exactly means a civil right when it relates to religious office? Over here, you will see that Hoffeld's table of analysis, the analysis that he has done related to the rights, is very pertinent. If I'll just read what the Supreme Court had stated, that a suit for declaration with respect to religious honors and privileges simpliciter will not lie in civil court. However, a suit to establish one's right to an office in a temple and to honors, privileges, remunerations, or requisites attached to such an office will be maintainable in civil court. So over here we see that it is not just it. For example, if I am a priest of certain temple, and there is an idea that just because I'm a priest, the bullocks or some animals need to bow before me. Now this is a privilege that I enjoy. There is no right, there is no duty against it. So at that time, I cannot claim that it is my civil right just because you didn't parade the bullocks before me. At the same time, if there are three families who have a right for performing some puja, and I like one of the family has been denied that right. At that time, yes, it is a civil suit because their civil right has been encroached upon. Now, people like the students who are studying jurisprudence, I would really like to tell you that if you're able to yes, if you're able to actually read section 9 along with Hoffel's analysis of rights, it will really help you. Due to paucity of time, I cannot go into those details, so I will move to the next part. While while drafting of a plaint, the another thing that is of utmost importance is knowing the jurisdiction. Always, because there are going to be election petitions, there are going to be some family laws, there are going to be cases related to IPR infringement. Every court has its own jurisdiction, and the statute provides that this type of case shall go only to this type of courts. That's the reason we have so many tribunals. We have labor courts, we have cooperative courts, we have debt tribunals, and likewise. So, plainly speaking, like Section 9 deals with jurisdiction, and we all know that there are three types of jurisdictions commonly known, that is pecuniary, subject matter, and territorial. So, I would just like to point out two things here, that there is always a presumption that the civil court has jurisdiction unless and until it is expressly or impliedly barred. So we come to the next part, that if I am filing a suit for a specific performance of an immovable property, for example, or any suit related to immovable property, Section 15 tells me that I have to file that suit where the immovable property is situated. Now, at the same time, if there is certain wrongs that have been committed against you, for example, defamation, someone, laws or the cases related to tort. So at that time, if there is a wrong done to you or to any movable property, at that time it is seen that always the court where the wrong has actually been committed has the jurisdiction, or the defendant, where the defendant resides, that court has the jurisdiction. Here the plaintiff gets two options, whether to go to the prior one, that is where the wrong has been committed, that jurisdiction, or to go where the defendant resides. Many a times we feel that defendant is at wrong, then why actually I should be made to file a case where defendant resides? It's actually giving me hardships. But the intention over there, it's really simple, that that where the defendant resides, that is the place where we have to file a suit, for the simple reason that the defendant has to go through hardships because someone else who has filed a suit against him. At the same time, when we're dealing with immovable property, the reason why we have a suit where the immovable property is situated is for the simple reason that that it is better for execution. It is better for actually understanding that what is the position of the property, and that is the reason why we have jurisdictional aspects related to it. Then when you're drafting the plaint and the client comes to you, there have been times wherein multiple suits have been filed earlier. They have been decided. Now comes the concept of res judicata under Section 11. When we are speaking about res judicata, the logic is simple, that there should be a conclusion to a litigation. Okay, I cannot keep on going and litigating against for the same issues against the same parties. That is the reason we have the concept of res judicata. And before the plea of res judicata can be given effect by the court, there are certain conditions that the person who is claiming the right has to, fulfill. The first one is litigating parties must be the same. Okay. The second one is that the subject matter of the suit also must be identical. Third one is that the matter must be finally decided between the parties by the competent court. And the fourth one, of course, that court should have jurisdiction. Res judicata also works in arbitral in cases of arbitration as well as awards. Now we come to the next part. That is, there might be cases wherein the client comes to you because the defendant, that the person against whom he wishes to file a case, have already filed a case before the civil court somewhere. This is one of the argument that I had heard before the commercial courts, that is before the district judge. Now there were two parties. Let's call it A and B. Okay, A party has filed a suit in some court in Gujarat, and B has filed over here in Pune. Both the courts have jurisdiction, but the matter that is related to the matter, the crux of the issue, the material facts, the remedies, all are interlinked and are nearly the same. So at that time, you need to advise your client that just filing of the case may not be sufficient over here, because we might have a stay order against us, that is a stay of suit. So it's better that you litigate, okay, in the case where it has which has been priorly instituted. But still sometimes the clients do press, this is different case. Okay, these are the facts which are different than the facts which have been earlier mentioned in the court in Gujarat. So at that time your argument will change a bit. Okay. Now what kind of argument will be over here is that this facts. So if I'm objecting to the state, I'll have to state, like I'm the plaintiff, I'll have to state that the material facts, the cause of action is totally different. Okay, there cannot be interconnection, and hence this suit can still subsist. Whereas if you see, someone has asked me that could you please point out differences between section 10 and 11. Section 10, it's basically stay of suit. Multiple suit has been filed. Both the courts are competent, but the suit that has been filed prior will always have, the court will have to proceed with that suit. And over here, there will be an automatic stay once the ingredients of section 10 are met in the latter suit. Whereas if you go to section 11, it's res judicata. Res judicata means that the dispute between the two parties have been conclusively decided by a competent court already earlier. Now, that's the difference. Like section 10, the case is still going on. In section 11, the case has already been decided. This is the difference between section 10 and 11. Okay. Uh, Now we go to the next part, that is rejection of plea. Whenever you're drafting a plaint, the basic idea while drafting is that the plaint should not be rejected. Order 7, Rule 11 deals with various aspects wherein a plaint can be rejected. Now, when we are dealing with rejection of plaint, you you have to understand that even in cases when an ex parte order has been there in your favor, that is, the defendant has not appeared, the court will still look into the aspects of section order 7, Rule 11, that is rejection of claim. You have to prove your case. Now, when can a claim be rejected? For example, when cause of action has not been disclosed. So, every time you're drafting a claim, there is always going to be a line which states that the cause of action arose first on this day. And while giving the plaint also, or drafting the plaint, you have to state all the material facts which actually takes you or takes you to the crux of the matter, that is the cause of action. Okay, the way I understand the concept of cause of action is simple. You know that if, for example, if someone is encroaching upon my right, then I have the cause of action. If no one is encroaching, then I will never have the cause of action, because there is no reasonable apprehension also that someone is going to encroach. Tomorrow I cannot go to the court just for a declaration that declares that this property is mine, again without any defendant. Whereas if someone is encroaching upon the right, claiming that okay, this is the property that I am entitled to, or I should have the possession, at that time, yes, of course, I will go to the court. At that time, I have the cause of action because someone has encroached upon my property. Now, when we are dealing with Order 7, Rule 11, and especially like right now you're students, so I'll tell you that usually when you start with any of the senior working in trial courts, at that time you see that more than drafting of a plaint or written statement, you have to draft all these small applications. So you need to know the nature of the application. Then, secondly, when we are dealing with rejection of claim, at that time it stipulates that the claim should not be, that the suit should not be barred by law. Now, there are two instances wherein I can just, for sake of brevity, I can give you the examples. One is Limitation Act. All of you know that once that specific period as mentioned in the Limitation Act has expired, you cannot file a suit. It's as simple as that. So at the same time, while you're drafting the plaint, you need to keep in mind that the limitation that you have drafted that the suit has been filed well within limitation period, and accordingly you proceed. There are checklists with the filing authorities many a time. So one, like, you have not mentioned the cause of action paragraph, you have not mentioned the limitation paragraph, you have not mentioned the valuation paragraph, so they call you again, and then you have to do the changes. So all of these parts actually constitute, of drafting a good plaint. Knowing this law is essential before you start drafting of the plaint. For example, Order 6 now. Order 6 deals with pleadings in general. Okay, so you will have Order 6 applicable to plaint as well as the written statement. Now, when you're dealing with Order 6, there have been certain parts which state that if it is a condition subsequent or condition precedent that you are claiming, you have to state in your plaint or in your written statement that you have fulfilled such condition, and that is the reason you are asking for the remedy. Otherwise, your plaint will not be a good plaint. Okay, then you will have to go for the amendments and everything. While discussing with Vivek, he also told that if you could elaborate on something like Court Fees Act and all. So before filing, okay, you should know what exactly is the court fee which you need to attach. Now, when we are speaking about the court fee, you have to see to it that what relief you are asking, what is the valuation of your suit. Then only you will be able to calculate your court fee. There is going to be ad valorem fees, which will change accordingly, and fixed fees. Okay, the Court Fees Act also like states that if you want to seek adjournment, uh, how much court fee you need to give at that time. Also, if you want to give an application, how much court fee. So it is quite in detail. The best way to learn is from the clerks. Okay, because they are the ones who deal with this every day, and even if you make a mistake, it does not matter. Okay, the filing department many a times they tell you, and the court also, if it tells you, okay, this that you have given lesser court fee, at that time you can always change, so it is not always going to be fatal. Okay. The next part that we are dealing is the description of the suit property. As I stated, Order 6 and Order 7 states that how you have to draft your plaint. So at that time, I'll give you a very interesting example over here. So in one of the cases related to Rent Control Act, Maharashtra Rent Control Act, a landlord had filed a case against, a landlord had filed a case against a tenant. Now, what happened was that the landlord wanted the possession of the tenanted property because because he wanted to have the redevelopment of the property and stuff like that. So, along with other compliances and all, he instituted the suit. But in the plaint, he gave a wrong description of the tenanted premises. This was a part, then we of course raised our objection in the written statement. Still, the landlord did not change it. The landlord had actually given lesser area than what we had expected or what it was actually the in possession. Now, because the landlord had given lesser area, we could state that yes, there are malefides attached over here. And that is the reason that the court eventually gave an order in our favor, the final judgment in our favor. So you see that when you're drafting a plaint related to immovable property, you need to know the property very well. You need to identify the property and you need to give the description of the property in the correct format. Okay. Now, the next part is the relief. Okay. Now, this is the most tricky part. Relief has to be drafted very properly. Okay, because eventually, what is operative is the order, the prayer clause that you write, whether it has been granted by the court or not. So, Order 7, Rule 7 and 8 states that the relief needs to be stated specifically. So there was a case, filed sometime back in 1990, and it was kept for final argument right now, just before the whole coronavirus thing started. And so the lawyer who had earlier drafted uh, this application, oh sorry, this plaint, he had written that uh, the sale deed between A and B should be declared as null and void. Now, our contention was nothing related to the sale deed. That is, our contention. We were also eventually, the case came to us quite late, and we were also supposed to state things related to it. Now, when I was stating that, that the relief that needs to be stated properly is for this reason, that because he had worded it that the sale deed itself be declared null and void, the court wouldn't be able to give us that relief because those people and that sale deed has nothing to do with us. But the case was actually related to the fact that the sale deed or the sale deed actually stated a few parts related to our property, and we were never a part of the sale deed. So only the extent of our property should be declared as the extent wherein the sale deed had mentioned about our property should be declared as null and void. So we had to propose an amendment. Fortunately, the case was ex parte, so the court allowed us the amendment, and we got the relief in our favor. That's the reason that while drafting a relief, it has to be drafted very properly. Then you come to the next part, that is section 34 of the Specific Relief Act. It states that mere declaratory relief can be given, but if you can ask for reliefs more than that and you do not do that, then the suit will fail. So, if, for example, I am asking for the ownership of the property, that this property belongs to me, and I refrain from asking for the possession, then the suit is surely going to fail. Hence, I'll always tell that, when you're having your first drafts, it's better if you show it to some senior or, to your professors or anyone, because eventually it is the interest of the client that is important and not your own interest. So always keep in mind that whenever you're drafting, that also is catered to. Okay. Now we'll move directly to the next part because I see that it's already 41 minutes. We'll deal with the parties to the suit. Now, when we're speaking about the parties, there are necessarily two parties. One is necessary party, and the other one is proper party. The civil court has abundant powers related to this. Okay, for example, a third party can make an application before the court that whatever will be decided in this case is going to hamper my rights, and hence that is the reason why I that is the major reason that why the case should be, or uh, my interest, or the party should be impleted. So this was the major reason why we have that order 1 rule 10 related to it, that the court can add or they can strike off the parties. So understand this idea that this part will never be available in an arbitration. In arbitration we always have only parties to the agreement who can be a party to the arbitration proceedings, or any person claiming through or claiming under the parties who are party to the agreement. But over here, civil court has wide powers. Okay, they can impede a party if they deem fit for that. And why is it necessary to identify the parties? Is for the simple reason that if you do not take a necessary party for the suit, then a decree that has been passed even in your favor, it is not going to operate against the party who is not a party to the suit. And that's the reason why we need to know that who can be the parties to the suit. Okay. The next step, once you have drafted the plaint properly and you institute the plaint, the next part that comes before you is an ad interim ex parte relief if you're asking for any. Okay, this ad interim ex parte relief is going to be only for a few time, like till maybe the defendant comes. There is another interesting part to it. If I have the apprehension that someone is going to file a suit against me and might get an ad interim ex parte relief behind my back, I can file a KVIT under section 148A of the CPC. So by filing of KVIT, okay, there cannot be any ex parte ad interim relief against me by the parties who have been mentioned in the KVIT. Okay, it is not a blanket. It's not a blanket KVIT that we can see over here. So the next part, even like I'll be dealing with the interim release in the end, of course. The next part that we have to deal is with summons. I won't go into the details of summons. Basic idea is that the summons need to reach the defendant. It can be either given by bailiff personally, or it can be substituted summons. That is by sticking it on a conspicuous place, and or through advertisement in the newspaper. And after that summons is duly served, then the defendant comes and appears before the court. Now comes the drafting of the written statement part. The role of the defendant starts here. So, as you all know, that drafting of the written statement basically consists of denials and establishing your own case over there. Now, when I state that I should be giving the denials, you should understand that why denying every, or the major admissions or the major allegations of the plaintiff should be denied. The simple thing is, if I admit anything inadvertently, the plaintiff can go for a judgment. Okay, judgment on the basis of admission. The same thing that you see even in the interrogatories. So, by drafting of written statement, the way you have dealt carefully with the plaint is the same way that you have to deal with the written statement. Written statement needs to be filed within 30 days, and if it is not filed within 30 days, up to 90 days for reasons to be recorded. If it is not filed, the plaintiff is always going to press for no written statement order. That is, you cannot give a written statement on record before the court. If you do not have a written statement, it's going to affect your case because there will be no defense, there will be no denials. And how are you going to proceed with the evidence stage? Everything collapses then. That is the reason why written statement is of utmost importance. Now, when you are dealing with the written statement and especially the no WS order, um, so it once happened that a case came pretty late to us, and we had to give our written statement. However, the delay was about 3 years, and when you are in college and especially when you are doing moot courts and everything, you get ample of time. Okay, you actually get ample of time to study on certain topic. This is not the case over here. My senior told me to argue for to set aside the no WS order. Now the delay was 3 years. It wasn't a delay of a few days, and I had to argue in about 10 minutes. So at that time, you understand that if as a student, you could have studied a bit more on the concepts in CPC. It really helps you in the future. So at that time, when we have to argue for setting aside the no WS order, you have to state that the delay was not intentional. That because the delay was not intentional, there are no malefices attached. There was a cause at why there was a delay. In our case, there was a huge fraud committed in the company, so there were no records in our custody, and so the delay was there. At that time, the judge actually made a very interesting comment. He said that, why didn't you file a provisional written statement? Now, I've never heard or read anywhere anything related to provisional written statement. But I have heard this from many judges actually, who state that, okay, if not a written statement right now fully, you could give a provisional written statement. And this is merely to tell that, it can be kept on record that yes, the defendant is diligently pursuing the suit. That is the reason they'll press for provisional written statement. It may not be a practice that every judge will adopt. So even if it is not so, there is always scope for amendment of the pleadings later on. It's there for the plain as well as for the written statement. So whenever you have to give a written statement, please see to it that it is done well within time. Then the next part is that when it comes to commercial suit, if you do not give a written statement in 120 days, your right has been forfeited. Okay. So for commercial courts, after 120 days, they cannot accept written statements. And whereas for the family courts, you see that it is exact opposite. Okay. The procedure in the family courts is such that once once a person institutes a suit, the summons have been served duly to the defendant, and the defendant comes to the court. At that time, the judge will not press for written statement. Okay, what the court states, or what the judge does, is that he sends for mediation or to a counselor. Now, there might be many sessions of counseling that can go between that period. It can go for a year, or it can end in a few months or something like that. Once the judge gets a report from the mediator or the counselor that there cannot be conciliation or there cannot be any settlement between the two parties, at that time, on that appointed date, the judge usually tells that, okay, file a written statement. But this is not a practice that every judge will follow. Even if there is a no WS order in a family court, it is fine. You can state that you can always go and go for setting aside of the no WS order, but there has to be proper reasons to it. When you are filing for delay condonation, that there has been a delay in filing of written statement, there has to be you know while going to it, there has to be a delay condonation application along with setting aside of no WS order or whatever it is. So while you are giving that delay condonation application, see to it that the delay has been explained properly. Vague uh, statements in the delay condonation cannot be accepted. Okay, it's a basic principle that you deal with under section 5 of the Limitation Act. Now we come to the next part, that is the counterclaim. Yes, so the counterclaim is basically plaint filed by the defendant. There's a difference between counterclaim and set off. In set off, there must be a suit for recovery of money. Then the amount must be ascertained, and such sum must be recoverable by the plaintiff from the by the defendant from the plaintiff. Now, the difference between set off and counterclaim is that set off is a defense, whereas counterclaim is basically nothing but a plaint. Okay, set off states that the plaintiff owes so much money to me, so I am putting for the defend, like there is certain amount that the plaintiff is claiming, so set off that amount, and this will be the final amount that I might be liable to pay. Whereas for counterclaim, even if the plaintiff suits fail at that time, my counterclaim can still go on. And that's the difference between, you see, set off and the counterclaim. Now, once you have given the written statement, Once the say for an interim relief has been filed, then comes the next part, that is argument for interim relief. Order 39 and section 94 and 95 deals with interim orders. So when we are stating that I want an interim order, what exactly does it mean? Interim order cannot be given in cases where a final order, such a final order cannot be given to you. That is the reason why interim relief and the final relief needs to coincide. At the same time, there cannot be an independent existence of interim order after final decree has been given. Okay, so interim order always merges into the final decree. So while we are dealing with interim orders, under Order 39 Rule 1A, plaintiff as well as defendant can go for interim order. Whereas under Order 39 Rule 1B and C, only plaintiff can go for an interim order. So the basic is that, the constituents of your plaint and the constituents of your interim application are going to be somewhat similar. Okay, when you're asking for temporary injunctions, there are three basic principles that you need to prove: prima facie case, balance of convenience, and irreparable loss. I would suggest you guys to look into or read the various blogs that are put up by the judicial academies. These blogs are actually, or these articles are actually written by the sitting judges, and it actually helps you in understanding that how the judge decides on certain topics. There is also one more aspect that the judge will look while awarding an interim relief. It is when they are, whether there is any necessity for giving such a relief. In one of the cases, it was seen that we had filed a case because we had a reasonable apprehension that the PNC authorities will demolish our structure. It was seen the PNC authority actually is not giving us any order, but every week they are coming on our door and threatening us to demolish the structure. That is the reason we filed the case, even though we gave in, like, all the compliances were done. The judge was not ready to give us an interim relief. And at that time, the basis that why he denied us the interim relief was simple, that he could not see that there is any necessity to give that interim relief. And that was one of the reasons why he failed, or why he didn't give us to give us the interim relief. As I'm dealing with interim relief, I'll just like to make reference to court commissioners also. Now, court commissioners is not something that you have to appoint only during the interim period. Even later on, the court commissioner can be appointed. You also can have it in your like the final prayer, that appoint court commissioner to settle the accounts or to verify the accounts of a partnership firm in a court, some things like that. So at that time, what is the evidentiary value of the court commissioner's report? That needs to be seen. When is a court commissioner appointed? To carry out certain local investigations, or of a witness, to carry out the examination of witness and something like that. You have the whole order, yes, section 75 to 78 of CPC dealing with the same, and order 26 also dealing with the same. Now, when I'm stating that there is a court commissioner appointed, it does not mean that my burden of proof is gone. If I have to prove as a plaintiff or a defendant some fact, or if I have to prove it duly, the burden rests on me. Just because I'm appointing or I'm giving an application for court commissioner, it cannot, refrain, or it cannot be one of the side that it's okay that even if I don't prove it, the court commissioner will do it. And that is exactly one of the contention, or one of the objection that is always raised against the appointment of court commissioner. Okay, the burden of proof which rests on you always has to be always has to be catered to by you only. You cannot appoint court commissioners for the same. Now, the report of the court commissioner is actually considered, okay, as an evidence. So when we state that the court commissioner's report is nothing but an evidence, it cannot be a basis for giving a final decree to you. Okay, you can always refute it. At the appellate stage also, there in one of the case, My senior had argued that there are various discrepancies in the court commissioner's report, and hence it cannot be the basis for the court giving an order against us. Thus, we see that from the process of pre-litigation, that is certain compliances that we need to do till the interim relief. There are so many laws that come into play. You have the specific relief act. You have those special laws. For example, as I stated, municipal corporation act. You need to know the limitation act, and so on and so forth. So as a student, what you can do right now is that while you are drafting something, or drafting while you're doing an internship, or drafting for your own fun, so at that time it's better that you start addressing these small applications. What is the nature of those applications? Many a times we make a mistake of arguing what is not necessary. Okay, if an application for court commissioner is made, I need to argue only on that aspect. I cannot argue on the overall case over here. Yes, I can argue that the burden of proof is on the defendant or on the plaintiff, and they are not discharging it properly. So at that time, but it should always cater to what kind of an application it is. Okay, for an application for no ws, I cannot, for setting aside of no ws, I cannot go forth and claim and state all the grounds for maintenance. Okay, especially when I'm dealing that in the family court. So please keep in mind it cater to the application over here, and do not go beyond that. If it is an application for rejection of plate, speak directly related to it. You need not go and state, okay, so this is what finally the Supreme Court has held in this case, and they had awarded such a remedy. It does not make sense. What is the application and how I need to deal with it? That is what you have to look into. I have got a few questions over here. I'll just scroll through it for a minute. Someone had asked if there is yes, a provisional written statement provision in the CPC. The answer is of course no. Then, if any more questions, actually you can type it right now, and I'll surely try to answer those questions. Yes, someone has written about decree on consent terms. So many times it so happens that there are out of court settlements. The the parties are parties just do not wish to go further with the litigation process. So at that time, a consent decree has is made, or the consent terms are given before the court. Now, when it has been given, it has to be seen by the court that the plaintiff and defendant, all of them, are present in person and has signed it. Okay, and then only you'll have a decree of consent. There is a proper procedure related to that in CPC. You can always refer to that. If that procedure is not complied, your consent decree cannot be, it cannot be stated that the consent decree has been made. The consent, I'll again repeat that the consent terms are given to the court. The court understands those. He'll ask that whether you have consented to this or not, and then he will give you this consent decree. It is executable. You can go for the execution of the consent decree also, unless and until it is the consent decree is actually got by fraud or coercion. Only then you can challenge the consent decree. Otherwise, you cannot challenge the consent decree. Mm. The next one is, what is the correct quantum of damages? Is there a law like Stamp Duty Act which determines the correct amount? Like, for example, in case of compensation for mental trauma. Okay, so I do not think that, see, basically when we speak about damages, we speak about law of tort. There is no tabular form given. How much amount has to be given to you? For example, if it's a money decree, okay, a money suit, at that time, from this date, from the institution of the suit till the final execution of the suit, the interest can be calculated according to the interest act. But otherwise, there cannot be any, proper act or quantification which states that if mental harassment has been caused, then this is the damages that you need to give. If you could logically connect this to the maintenance part, Okay, not everyone will get the same maintenance. Okay, a person who is like very rich and she asks for the maintenance from her husband, her maintenance is going to be nearly salaries of most of the people in India. And whereas if a person who comes from a very humble background, at that time her maintenance is not going to be so much, it might be in some hundreds or thousand rupees only. Um, The next one is, yes, could you please explain in detail about obstructionist party, plaintiffs, defendants, and how are they brought on the record? So I would like to say that the obstructionist part comes into play when you have execution, like you are going for execution. Under Order 21 Rule 97 to 106, you have the obstructionist proceedings. Now, as you are speaking about like parties to be brought on record, Order 1, as I have already stated, Order 1, Rule 10 speaks about it that the court may add the parties. Now, so for example, like in one of the cases that we are dealing, uh, there was an application made for adding one of the party. So at that time, so we are the applicants, and just because that party has given a third party application, and we are not going for an objection, because if that party is actually going to come into play and the decree will be drawn accordingly, and it's going to be binding on them also. The role of the third party, if it is helping your case, generally the lawyers take a stand that okay, we will not obstruct it, okay, we will not object to that application. But if it is going to unnecessarily cause hardships and there's no need of that party, then of course you can object for it. Again, I repeat, order 1 rule 10, you have the provision related to it. uh, at any stage of suit, whether interim relief can be sought from court. I would like to explain that interim relief is basically something that takes place while during the suit. However, it has to be always prior to the final decree. Okay, there have been times, so the idea why you have the interim relief is to safeguard the rights of the plaintiff or the defendant accordingly. Now, anytime before the final decree, if I have the apprehension that my property might be wasted or my interest might be hampered, I can go for an interim relief. Okay, it need not be filed always with an exhibit, like always with the plaintiff itself. So, I feel that before you go for the final decree, interim relief can be given to you, and it is operative only till the final decree is made or drawn. The next part is settlement happens in front of court. Though the party have denied later at the time of execution of terms, dates expire. Will this be appealable by that respective party? So basically, this won't be a part of appeal. If you've already gone for execution, there are various modes through which the decree can be executed. If the people are not helping, if they are not complying with the orders of the court, then of course there is always in execution petitions we write that a receiver may be appointed, a commissioner may be appointed for the possession or the partition, and likewise. So, it need not always be that you have to go in the appeal. What is once the decree is drawn up, if you have no grievance against it, you always go for the execution. Okay. Now it is the role of the other parties to actually, they if they are stating that the consent decree is obtained by fraud or something, at that time they have to file a suit for the same. They have to go in the appeal, and not the person who actually has a decree in his favor. So I think today the questions are also done, and we can stop here today. We'll meet in the next session if possible. And I hope that like any other questions that are coming up right now, I'll surely deal with that in the next session, because as it is, I'll be dealing with execution proceedings then. So execution proceedings review and appeal and so forth. So for today, I think we'll end the session here. And thank you. The questions were really interesting, and it was a great experience for me too. Meet you the after tomorrow now. Thank you.